Mr. Johnson was relaying most of the information back to the attorneys on the other side, defense attorneys. I can confidently tell you and truthfully tell you, sir, that I never solicited that language to be in that order. The order, as you'll note, as well as the motion, were brought to the court on January 11th, 2010, the very day that the matter was scheduled to enter a plea in the case. If you'll note, on January 11th, 2010, on the order that you've handed me and marked as Exhibit 3, you will see where I started to write something out on the side beyond that. If you'll look at that for me, you'll see that I started to write something on the outside concerning the use of funds subject to approval of the Harlan Circuit Court. It was my belief at that time, and you heard the lengthy discussion, or not lengthy, but the discussion I gave the Commonwealth Attorney about this not being used for certain entities. And as a courtesy, I didn't just blurt out, I don't want this money, this settlement agreement, putting money in the Sheriff's Department's political branch arm of the Chaplain's Corps. I started to write, said funds shall be the sole property of the fiscal court subject only to the limiting restrictions in court's orders. That's what I had started to put out through there. And you can see where I started to write that.
May I approach, Mr. Chairman?
Yes. And I initialed it. The reason I stopped doing that during that hearing was I believe that, well, it's not the best language in the world, but I can live with that to do the orders, to designate the donations, to make sure it doesn't end up in someone's hands. I took into account, well, I'm sure Mr. Johnson told them to put it in there. They sent it to these lawyers in Tennessee. They show up with these motions. And quite frankly, I believe that what Mr. Johnson had told me, this language was going to accomplish that, although it was not the best language to accomplish what we had discussed. And as you can see, I started to change that language then. And as I sit here right now, I wished I went ahead and wrote out what the Lord put in my mind to write out, because you would have seen exactly what went on at that time period. And you can see as it starts out, said funds. And that's the way I was going with that. That is the reason. I never solicited this language. I never asked for this language to be in there.
All right,
I
so
started to correct the language when it happened at the day of the hearing, but I thought, well, this case has gone on for years. This is a much less complicated way to do it. We'll get it done, and we'll do the orders and send the orders over to fiscal court. Yes.
let me show you exhibit.
That's my answer to that. I don't know what to tell you other than that.
I get a few follow-up questions, but let me show you exhibit number 7. This is the order that was entered in the Dr. V case, 481-1.
Yes.
Has the exact same terms, does it not, as the Dr. Lalani order? For the record, that's exhibit 7.
It does.
All right. And I don't see any handwritten language or attempts to edit that on that particular order, is there?
No, sir, there isn't.
All right.
But I got this order subsequent to the other order, and I'd already made my mind up, well, I'll just live with the language they have in it.
And if I understand your position, then correct, Judge Allred, is you didn't solicit the language that was set forth in the January 11th orders, correct?
I've answered yes.
All right.
If I was over there,
But
I'd
you
object,
certainly,
and answered yes.
but by virtue of your entry of those orders, you certainly approved the terms of those agreements, correct?
I approved the terms as I understand them, what I understood those terms to mean from my prior discussions with the Commonwealth Attorney in my office, yes.
Okay. Now, moving to a different subject.
Yes, sir.
At some point, it's my understanding that the Sheriff's Office in Harlan County began an investigation into an allegation that there was drug sales taking place by Judge Grisham out of his office based on an allegation made by a woman named Ms. Hensley. You familiar with that allegation?
Yes, I'm very much familiar with that allegation.
And when did you first become aware that the Sheriff's Office was conducting an investigation into Judge Executive Grisham and the allegation that he may be selling prescription drugs out of his office?
When did I first become aware?
Yes, sir? That an investigation was underway?
I would say it was when the sheriff's office notified me of such fact.
And do you recall when that was, sir?
Well, from my review of the file, it appears that September 1st may have been the first time the sheriff's office sent Ms. Hensley into the judge executive's office. So it would have been sometime after that, probably in October of 2009. And the best of my recollection, that has been almost 2 years ago.
Understood. And did the topic of this investigation come up when the sheriff asked that you continue a pending case involving Ms. Hensley?
I do not recall that, sir. I do not recall that conversation happening.
With the drug problem in Harlan County, and I'm sure as circuit court judge, you've dealt in cases before with drug informants who may be producing results or working with law enforcement. That's not uncommon.
No, it's not uncommon.
And is it uncommon for the Commonwealth Attorney or the Sheriff's Office to ask for continuance of hearings involving informants until their participation is concluded?
That is not uncommon. It was not uncommon during the time period from 2007 through 2000 and I guess that would have been 2009. 2010, I indicated because of the false allegations in the Sheriff's Department, I indicated that I would no longer entertain any such requests. They need to go through the Commonwealth Attorney's Office and put those on record. So that time period, yes.
Right. So sometimes, if I understand what you're telling me correctly, Judge, is that the Sheriff's Office would make that request. Now it has to come from the Commonwealth Attorney.
Absolutely.
Right. And you just don't recall in this particular case, you don't have a specific recollection of the Sheriff's Office coming to you asking for a continuance of a hearing involving Ms. Hensley because of some assistance she was providing to the Sheriff's Office.
Are you asking if that is what occurred on the day that I first became aware of the investigation?
I'm asking you if you recall a request from the Sheriff to postpone or continue a hearing for Ms. Hensley because she was assisting them in an investigation.
I don't recall that. I recall being over at their office, I'm thinking to sign a search warrant or an arrest warrant, which I did on numerous occasions, and the sheriff was very gleeful or serious about what he had.
And did you, at that initial, when you were there at that initial meeting you just identified, is that when you first found out about the allegations involving Judge Grisham?
Absolutely. I think that quite frankly, I didn't believe it and was amazed, shocked, is a better phrase, shocked.
And at that point, did you ask to review videotape of the attempted buy by Ms. Hensley from Judge Grisham that had been recorded by the Sheriff's Office?
When Marvin Lipford advised me that was going on, I advised him that I didn't believe that. And Mr. Lipford said, well, there's a possibility of warrants, and we're going to take this to the grand jury and do these things. And I said, well, if you've got something like that, you better have a really good evidence. Don't come to me asking for a warrant or a search warrant or anything on the judge executive unless you've got really good evidence. And that's when he said, well, I've got it right here on my computer. Look.
And did you look at it?
I did.
And how much time did you spend reviewing that tape?
However long the tape was.
And did you draw any conclusions?
You know, I probably stopped it. I actually probably told him to stop it through there.
And did you draw any conclusions, Judge, after you reviewed that tape?
Did I draw any conclusions?
About what the tape showed, whether it showed evidence of some type of illegal transaction between Ms. Hensley and the judge, whether it was inconclusive, whether it didn't show anything? What did you draw any conclusions after you reviewed that tape?
When I reviewed the tape, my analysis was probable cause. As a judge, I am called upon to make the analysis of probable cause constantly in regard to search warrants and arrest warrants. When I viewed the tape, I was viewing in the context of a circuit judge sworn to uphold the law, talking to a law enforcement officer who told me he had a legitimate criminal investigation going on and the potential of an arrest warrant or search warrant. I reviewed it the same way I do any other affidavit or evidence presented to me to review for probable cause. And after reviewing the tape, it became evident to me that I felt there will be probable cause for a search warrant at that time, or arrest warrant, whichever they asked.
And had the sheriff asked you for a search warrant when you came over to the office involving Judge Grisham's investigation?
He did bring the discussion up, yes.
Have you seen any document in which the sheriff was applying for a search warrant? I mean, that's got to be done in writing, correct?
If you issue a search warrant, yes.
All right. And did he have a document there asking for it with a complaint, with a
No,
sworn
sir.
affidavit or
He
anything to get a search warrant?
No, he didn't.
And did he have an affidavit or complaint for an arrest warrant prepared for you to sign?
No, he didn't. Up, yes.
And did you express any concerns during this meeting when you looked at this particular videotape that this might constitute some type of ex parte review of the evidence if this case came before you?
I did not feel that was ex parte, as he was requesting or talking to me about potential for search warrant or arrest warrants. The gist of it was, we'll be coming to you soon. And I said, you better have really good evidence, because if someone shows up at my door with an arrest warrant or a search warrant for the judge executive and it's on an affidavit and piece of paper, quite frankly, a piece of paper ain't going to cut the mustard. And I had to see something to back up what they said. So my understanding was they would be coming to me someday in the future for that.
And did you know Ms. Hensley before that day? Had you heard anything about her, handled any cases that, you know?
You know, I was a public defender for a while in Harlan. I did defense work in Harlan for a while, and I handled a lot of cases. In fact, I think about the last year I was in practice, I had about 350 or 400 active cases. And I did a lot of criminal defense. I did a lot of domestic work. So somewhere along the line, I may have represented her as an attorney years ago. I don't recall, but wouldn't surprise me that I had represented her in an unrelated matter. Yes, probably.
At the time that you reviewed the tape, did you know that Ms. Hensley was the person making the allegation against Judge Grisham?
If you know Ms. Hensley, you'd be hard to miss Ms. Hensley.
But
Okay.
you knew she was the one who was involved in the alleged
Usually wears
purchase,
a wig about 4 foot high. Yes,
and she was the one who was making the allegation.
It became evident. Yes.
And did you know that she had a known history of drug abuse,
Yes.
and that she had a criminal record involving drugs?
Yes.
Now, did the sheriff tell you at some point, either at this initial meeting or later, that the matter had been also referred to Jack Conway's office, to the Attorney General?
To clarify that for you, sir, I was the one that advised the sheriff that this was a matter for the federal authorities and the Attorney General's office. And I indicated to him, if the matter was presented to a grand jury, that I would probably recuse if they returned an indictment. I was the one suggested Mr. Lifford contact the Attorney General's office and federal authorities in regard to this issue.
I'm sorry, Judge, if my question was confusing.
Yes.
At any point during the meeting, did Sheriff Lifford tell you that this matter had been referred to the Attorney General?
You know, I don't recall him saying that. I really don't.
At any point in time, did you come to learn that the Commonwealth Attorney had advised, first of all, back up, at some point did you become aware that the Commonwealth Attorney had been briefed on this investigation by the sheriff?
Yes, I did become aware of it recently, yes.
And did you become aware that the Attorney General's office had performed an investigation into Ms. Hensley's allegations against Judge Grisham?
I became aware of it when the grand jury, the regular grand jury, returned a no true bill. Mr. Johnson at a press conference. And I also became aware of it recently by listening to a taped interview of Roger Sizemore, where he said the Commonwealth Attorney had advised him of the Attorney General's office investigation prior to the matter being presented to the grand juries.
Do you recall a meeting, sir, in April, it's the best I can do from a time frame, 2010, in which you discussed this Grisham investigation with the Commonwealth Attorney, Henry Johnson?
To the best of my knowledge, I think somewhere in that neighborhood, yes.
And during the course of that conversation, was the status of the investigation discussed with you?
You know, I'm thinking it probably was, because that was the time period that the discussion of the special grand jury was going on and things of that nature, yes.
Right.
To the best, I mean, I really don't remember that well, but I'm sure there was some kind of status with it.
And but I think we're in agreement. I think I heard you correctly that there was a meeting that you recall taking place with Commonwealth Attorney Johnson before the special grand jury order was entered.
Let me say this to you. I'm not sure about the date of April the 10th, okay? I was thinking the date of any meeting that I had with Mr. Johnson would have been a later date. The reason being is because Mr. Johnson and the sheriff's office had decided to present Mr. Grisham's case to the regular grand jury on the Monday before the special grand jury order was entered. And for some reason, he didn't do that. There was no special grand jury order in at that time. He chose not to do it. He came to my office, and that's the meeting I remember with him, and indicated there would be a lot more work in this case. We're going to need this special grand jury. It can't go to the regular grand jury. We're going to probably have to get some people out of Bell County. I agree with you. We need to do that. He said, I'll probably recuse if there's an indictment. And I said, I will definitely recuse if there's an indictment in this case.
And
That's the conversation I remember having with him.
that's where the topic of the special grand jury first surfaced.
No, sir. Mr. Johnson had discussed it with me previously.
And that's what I want to get at. I want to make sure I get these meetings down correctly, and so that we can, trying to go chronologically here in terms of making sure I understand the sequence of what occurred, because I think that's important. All right, so you had a meeting with the Commonwealth Attorney in April of 2010. Can't recall the date, but that meeting, you were briefed on the status of the investigation involving Judge Grisham, correct?
You know, I don't remember a status update. I just remember, and it wasn't a long meeting or anything of that nature. He simply said he's still looking into whether or not there needs to be a special grand jury, still looking at what kind of case they have. The way I recall it, Mr. Johnson at that time had indicated he didn't know much about the case. He said that he would have to get up with, I remember that now, he said he would have to get up with the sheriff to figure out what's going on in this case. That's what he told me. And then the next week, it's going to be presented to the regular grand jury. And then he comes into my office and says they can't present it to the regular grand jury because it's going to have to go to the special grand jury, and that he agreed we needed a special grand jury, and he wanted a special grand jury. We may have to get jurors out of Bell County. We'll have to voir dire them to make sure there's no conflict. We wanted this to be above board and honest and fair. And that's the way I took it. And I went with exactly what he told me. I still, to this day, do not understand why the Commonwealth Attorney and the sheriff didn't go ahead and present that case to the regular grand jury on their own initiative, why they stopped it, and why he came to my office after that. But the meeting you're talking about, I remember a little better now, because that's the meeting where the Commonwealth Attorney seemed to act like he didn't know. He brought it up to me and just kind of said, well, I really don't know enough about this right now. I'll get up to speed on this, I think was his phrase.
Before the order was entered on April 22nd of 2010 in the Harlan Circuit Court, were you informed by the Commonwealth Attorney that the Attorney General's office had concluded its investigation and that they found that there was no basis or evidence to support the allegations against Judge Grisham?
I do not recall any conversation with the Commonwealth Attorney about the attorney. I don't recall it.
Do you recall a conversation before April 22nd of 2010 in which the Commonwealth Attorney told you that he had serious concerns about the credibility of Ms. Hensley?
I don't recall him ever giving me any inkling that he had serious concerns about the credibility of Ms. Hensley. The first that I recall that ever came up was when the Commonwealth Attorney started giving his press conference and talking about the misgivings they'd had with her. And I'm thinking when Mr. Hensley had indicated Mr. Johnson had asked him about the credibility of his sister, State Police Detective Hensley. That's when the day the grand jury was meeting, he was going to the regular grand jury, is when all this came down on top of me, to be quite frank with you.
Was there, before April 22nd of 2010, was there I apologize.
Take your time.
Was there a discussion before April 22nd of 2010 with the Commonwealth Attorney that this matter needed to be cleared up with Judge Grisham? It needed to be presented to a grand jury so that the citizens of Harlan County wouldn't think that this particular investigation and these allegations had been swept under the rug, for lack of a better term?
You know, it seems like he had mentioned something about that in regard to presenting it to the grand jury. I mean, you know, that's been a long time ago. I mean, I can't remember every specific detail we had in the discussion. I don't remember any kind of big point being made about that issue, but I am very clear that he wanted the special grand jury convened. And the point that clears it in my head the most, and the thing that made my mind up as a judge when he requested it, was the fact that he had just attempted or had indicated he was going to present it to the regular grand jury where no one had ever known about it. there would have never been any person on earth even known that case had gone to the grand jury outside of a no true bill being returned. And he comes to me, to my office, and tells me that this case can't be presented to the regular grand jury. We need a special grand jury. We're going to need those 50 jurors out of Bell County. And I do what I think my job is as a chief circuit judge. And that's what I recall from the conversation after that. The one before that, to be quite frank with you, I believe the gist of the conversation, the one in April before that was a very brief one. He indicated he really didn't know much about the case, and he would have to get up to speed. Now, that's what's kind of surprised me about all this, where I see Mr. Johnston's statements talking about how he was in on it from day one and working with them and things of that nature. But what he had led me to believe at that time period is he really didn't know much about it at that time, and he was going to get up to speed on it. And then my next conversation with him is he's not let it go to the regular grand jury. He's asking me for a special grand jury. He's talking about 50 people from Bell County coming in and being voir dired. That's what I recall about this. And quite frankly, as a circuit judge of Harlan County, as a chief circuit judge, I wish they never brought that garbage to me. I wish the sheriff had never even mentioned that to me. I wish the sheriff had simply done his investigation, turned it over to somebody else, and gone from there. And I wished that I wasn't in a position where I had to do my job. But when you run for an office and the people put you in there, you do your job, no matter who the person is.
Judge Allred, did
Yes.
you feel, I mean, you were aware of the timing. I mean, this is April of 2010. There was a primary election in May of 2010. You're aware of that, correct?
Very aware.
All right.
Yes, sir.
And you knew that Judge Grisham was up for election in that May primary, correct?
Absolutely. Who didn't?
And you knew that he was running against your cousin, Denny Pace, for judge executive, correct?
Denny Pace is a second cousin whose
I'm
house
sorry,
I've
Judge.
never
See,
been to.
did you know that? Did you know that he was running against
Yes.
Denny Pace?
I knew he was running against Denny Pace, my second cousin. He's running against Marvin Lipford's ex-daddy-in-law. He's running against Sean Miller. There was a whole bunch of relatives of different people involved in the elections in Harlan County. And one of them was the sheriff's ex-daddy-in-law.
So, in light of your awareness of the fact that this is all coming about with this primary election coming up in May, did you feel it was important for a grand jury to convene in order to address this before the election?
I felt that I had to do my job. When the Commonwealth attorney came into my office, and it was the Monday before or early Tuesday before the Thursday I entered the order, and laid it in my lap and told me these things and said that. Let me say this to you. I didn't make this decision lightly. I prayed about it. I stewed over it. And I said, I know that I will receive a lot of repercussion for doing my job. But the simple fact of the matter is, Mr. Mando, in Harlan County, when it becomes election time, people get killed. And I was led to believe that this person was in danger. From the sheriff's, the way he laid the case out, the way the Commonwealth attorney was talking about we're going to need special grand juries and things of that nature. Let me say this to you. I didn't make this decision in Harlan County that I prayed about and convene a special grand jury is the chief circuit judge. And I'm the chief circuit judge, I'm the regular circuit judge, I'm the divorce judge, I'm the EPO judge. And the simple fact of the matter is the worst thing that could possibly have happened, in my book, is a witness turn up dead or someone turns up killed in a situation like this. And that laid on my mind heavily when I did the special grand jury order. And I did that order as soon as practical after praying about it and contacting, quite frankly, other judges to give me some advice on that, one of which was Jim Bowling, who used to sit on this commission, a person that I've contacted numerous times to give me advice. Unfortunately, in my case, Mr. Bowling was gone for a week and didn't get back to me until after the matter was over. It was my belief that I did the right thing, that I did my duty as a circuit judge, and I did it for no other reason than it was my duty to do my duty as a circuit judge, and I believed it was right to do that at the time.
Judge, on April 22nd, did you have occasion to come before you on that particular day, a hearing on a civil case, Potter versus Howard?
I did, April 22nd, I remember that date.
It's my understanding that Potter versus Howard was an 07 case,
Correct?
and it was a wrongful death action filed against James Howard.
Yes.
He was the defendant property owner in the case, as I recall.
He was defendant property owner. I believe it might have been one of his companies or him, one of them. I can't remember.
And am I correct, sir, that Mr. Howard had been a longtime supporter of Ron Johnson, the former circuit court judge who you beat in the election? Is that correct?
Yes, he did support Ron Johnson, to the best of my knowledge. I didn't go into the voting booth with him.
And in that particular Potter versus Howard case,
Interestingly enough, he had actually supported me in my district judge race years ago.
let me show you what I've marked as exhibit number 8. This is a motion and notice for recusal in the Potter versus Howard case.
Yes.
And if you take a second, page through that, see if you can refresh your recollection about that motion.
Thank you.